Hello, good afternoon and welcome to Law 2021 Online Residential Properties Shape the Debate, hosted by myself, Amanda Tice from the Solicitors Group. In this live session, you can put your questions to Peter and David and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So moving on to our introductions, first of all, we have Peta Dollar, who has over 25 years experience of practicing property law. She's a real estate partner at Dentons for 17 years and is now a full-time freelance lecturer, trainer and writer, providing training on behalf of organisations as well as in-house training for law firms and local law societies. Peter is a member of the Consultation Board of Practical Law Company and Editorial Board of Landlord and Tenant Review, and is the site editor of the property law website www.propertylawuk.net. She is the co-author of 2 books on the Landlord and Tenant Act 1987 and writes 5 sections of iServe, the information resource for RICS. As part of Law 2021 Online, Peter's sessions include easements and restrictive covenants and overage. Moving on to David Keighley. David was admitted as a solicitor in 1982 until his retirement from full-time practice. He was a partner and head of residential property at a legal 500 firm. He now uses his extensive experience and understanding of practical conveyancing to cut through the academic niceties and make things relevant for the busy practitioner. He is a contributing editor to the Law Society Conveyancing Handbook. As part of Law 2021 Online, David's sessions include shared ownership lease and residential property, a practice update. So to kick off, we'll start with addressing some of the pre-submitted questions we've received. So first we go to Peter. So over to you. So first question is, what happens if a restrictive covenant is used to secure overage? Will the covenant bind the original covenanter?
Thank you, Amanda. Well, the answer to that is, the short and simple answer is, yes, it will. The problem, of course, with securing a restrictive covenant through the, let me start again. The problem with securing overage through the use of a restrictive covenant is that the burden of that covenant will not run with the land. That's the point. Normally, you use a restrictive covenant in order to impose a burden on the land, which will be imposed on subsequent owners of that land. However, in the case of a covenant to secure overage, it won't work. The burden will not run with the land. However, the original covenantor will still be bound, and that was illustrated in the Cosmic Home case, which I referred to in my original presentation.
That's great, thank you. So next question is for David. So is there a limit on the amount that a housing association can be asked to pay for external or structural repairs?
Yeah, thank you, Amanda. But this question, to some extent, will depend on which version of the lease is being used. If we're talking about the 2021 version of the lease, which I covered in my presentation, then only if that lease is used will the housing association have any responsibility to actually pay for those repairs itself. As I think I made clear in the presentation, or mentioned in the presentation, in the existing lease use up to until earlier this year, the shared ownership lease of a house, for example, all of the responsibility for the maintenance of the repairs was for the sole responsibility of the leaseholder, even if they only owned a 25% share of the property. If that same house was granted under a lease under the new 2021 lease, then the housing association has an obligation to pay all of the costs for those structural and external repairs throughout the first 10 years of the lease, or subject to the limitations within the lease. But essentially, the answer is, if it's a pre-2001 version of the lease, then the housing association is unlikely to have any liability itself. It might have a liability if it's the landlord to carry out those repairs, but he won't have to pay for them. They will be at the expense of the tenants. If it's the 2021 lease, then the housing association is under an obligation to pay all the cost of external and structural repairs, and it cannot use any reserve fund or money built up by the tenants for repairs to do that. It has to pay it out of its own money.
That's great, thank you. So moving back over to Peter now. Have you come across an easement of airspace to allow a balcony to overhang a neighbour's property?
Well, this is an interesting one, because you might logically think, how am I going to document this? I suppose the obvious way to document the right to overhang a neighbour's property in this way would be to have a licence, but there are drawbacks in using a licence. So what about using an easement? The problem is that although the class of easements is not closed, and what I mean by that is that there are lots of different types of easements that we've seen: rights of way, rights of drainage, rights of light, all sorts of easements. But the class of rights that can be easements is not yet closed. And indeed, we saw not that long ago in the Regency Villas case a new easement being created, which was the right to use a swimming pool and a tennis court. So could the right for your balcony to overhang your neighbour's property exist as an easement? Well, the answer to that is no, because the whole point about an easement is that it cannot effectively oust all benefit in the land for the owner of the burdened land. So a right of way can be an easement because you can drive your car up and down somebody else's road, but obviously when you're not driving over the road, they can drive over the road. But in the case of a balcony overhanging somebody's land, that airspace which the balcony occupies is effectively taken away from the owner of the burdened land. And therefore it cannot exist as an easement because you have taken away the entire benefit of that airspace permanently from the person who previously owned it. So it's never been held that such a right could be an easement, and in fact it could never actually be an easement. It could not exist as an easement.
Okay, that's great. Thank you for that. So coming back to David now. So how will I be able to tell if a new home has been built using funding agreed by Homes England after 1st of April 2021 and that the lease used needs to be the 2021 version?
Yes, thank you, Amanda. I think this is it's a very pertinent question. The answer is you won't very easily. The only way to know for sure is going to be to ask the housing association. I mean, the point here is that only leases, only properties which are built using funding agreed after the 1st of April 2021, only then will the housing associations have to use the new version of the lease. And as I think I made clear in the presentation, my view is that the housing associations will try desperately not to use this new lease until they absolutely have to, because it imposes some fairly stringent obligations on them, which they don't have under the current version of the lease. So the answer is to that question is the only way to know is to ask. Having said that, I think, as I mentioned in the presentation, I suspect that the 2021 lease probably won't come into usage until later this year or possibly even next year, because if you think about it, if a house is being built, if funding for the development was only granted on the 1st of April, the chances of it being sufficiently built now to be ready for sale is remote, unless, as I said, unless you're buying it off plan. But so I suppose the answer is the only way you'll know is A, if you've had the 2021 lease, then fine, just don't upset the apple cart and don't raise too many questions, just take it. But if you have a suspicion that if it's a new build which started after April, then ask the question is probably the answer. It's the only way you'll know for sure. There's no other definitive way that I'm aware of finding out.
That's great, thank you. We've had a live question come in, David, that I think relates to what you've just been talking about, so please bear with me.
Okay.
You mentioned the new clauses will only affect properties that are built using the money from the next financial year's money. Has the amount been defined, as developers would perhaps mix funds from the previous money pot and the new money pot to allow them to keep the pre-2021 version of the lease? As this is clearly more favourable for the developers as leaseholders, it will be interesting to see from the commercial point of view how the crossover from pre-2021 to post-2021 leases affect how the property is valued.
Yeah, I'm not sure it's going to be that easy to mix the funding, because effectively projects are allocated funding from particular tranches of money. So any development that was funded prior to April 2021 will continue to be funded out of the prior to April 2021 pot. It's only if it's taking money from the 21 to 26 pot will it be used for the new lease. My other view is I'm not entirely sure that developers, as in commercial developers, actually take advantage of the Homes England funding anyway. They tend to use their own money and to build the properties rather than relying on grant funding, because grant funding is primarily given to the housing associations and not to the private developers. If the housing association, if a private developer, Wimpy or Barratt or somebody through their own shared ownership arm are building, then arguably they could use the pre-2021 lease if they haven't used any element of public funding and could continue to do so. The issue, I suppose, is in many cases the mortgage lenders pitch in here, and in some cases the mortgage lenders have a specific requirement that says that the current version of the lease must be used when the lease is granted. So it's a catch-22 to some extent. If they try, if they don't use public funding, then they don't have to use this 2021 version of the lease. If they use any element of public funding which was after 2021 funding, then I suspect they're going to be forced into using it by the terms of that grant and also by the mortgage lenders. But I agree, as I made the point, the lease itself is very much in favour of the tenants and not the landlords, and so I suspect the landlords will be keen not to use it until they absolutely have to.
That's great, thank you. So we'll give you a little bit of a rest there, David. So
okay.
Does a buyer have to pay SDLT on overage?
Well, SDLT is basically payable on the consideration paid for the purchase of land. Overage, where it's not definitely payable and very often it's not quantifiable, basically the requirement in SDLT terms is to estimate what the overage will be. And that's obviously easier said than done, but that's what you're supposed to do. You're supposed to estimate what the overage will be, and you are then supposed to add that amount on to the fixed purchase price and pay SDLT on the whole lot. And then if and when you find out that the overage was actually paid and how much it was, then you're supposed to do another SDLT return, basically paying any excess money that's due, or indeed getting a refund if you've overpaid. However, where it is possible that that overage will be payable more than 6 months after completion of the sale and purchase, the purchaser can actually apply to HMRC to defer payment of SDLT on the overage until such time as they actually know that it's going to be payable and how much it will be. So that's a real advantage from a cash flow point of view, and also saving on all those annoying administrative details. If it is possible that overage will be payable more than 6 months after completion, then the buyer can basically forget all of that. They need the consent, they need the approval of HMRC, they need to apply for that approval to defer the payment of SDLT on the overage. If they apply for it, however, they will get that approval, and that will then save them both cash flow and administrative inconvenience.
That's great, thank you for that. So moving back over to David, can an owner staircase buy the annual 1% allowance at the same time as buying a further share using the general staircasing right?
Okay, thank you. I'm going to be a thorn in the side of the people who drafted the lease again, and I think they're probably fed up with me on this, because I've been a thorn in their side for quite some time on various points, and I think, as I said in the presentation, one of the things I've been banging on for years that they need to change, they've actually finally listened to me and changed it in the new lease. But the bottom line is that it doesn't actually make it clear either way in the lease. My suspicion is the answer to that is yes. Because the 1% allowance is in addition, and it makes it quite clear in the capital funding guide that the 1% purchase is in addition to the general right to staircase. So in theory, there might be an advantage possibly to somebody buying an additional 1% at the same time as buying a share under the ordinary staircasing provisions, because of the way that the prices are calculated. The price of let's say you're staircasing an additional 10% share using the normal staircasing right, then that price you pay for that will be calculated based on the specific value of your property. But the 1% is not based on the value of your property, it's based on the general house price index. And the Housing Association will have given you an amount that you have to pay for the 1%. So I suppose, if, for argument's sake, if you're buying a 10% share and the additional 1% is going to cost you less than 1/10 of the 10%, then it makes sense to say, yeah, okay, I'll buy 10%, and I'll also buy another 1%, and I'll get my 1% at a lower price than I'm paying for the equivalent amount under the 10% staircasing. But bottom line is, yes, I don't think there's anything to stop you doing that. It may have its advantages. It may have its disadvantages, depending, I suppose, on valuation. I'm not convinced, as I think I said in the presentation, that the 1% staircasing is going to take off in a really big way anyway, simply because the costs involved are probably going to be disproportionate to buying a 1% share. But we'll have to wait and see. But yeah, in theory, no, I can't see any reason why you can't do both at the same time. I think actually this was a point which somebody made when I did a live session the other day, is that surely the 1% is going to make it difficult to know. You've got to keep the final share has to be a minimum of 5%. You're going to have some people with sort of potentially very odd percentages, because if they do 5% staircasings and 1% every now and again, you're going to get somebody owning, at the moment it's always in round figures of 5 or 10%, whereas you could end up with somebody having a 23% share in a house or whatever. So it's arguable, yes, there will be some slightly odd percentages being traded, but we'll have to wait and see if it takes off.
Great, thank you. So moving back to Peter now. So can solar panels benefit from a right to light?
Well, that's a really interesting question, because obviously buildings can benefit from a right to light, but specifically it's not the building that benefits, it's the apertures in the building, which normal people who aren't lawyers tend to call windows. And in the same way, a piece of bare land cannot benefit from a right to light. So if you've got, for example, a field on which you're farming and somebody wants to build a huge structure next door that completely shuts out all the sunlight to your the land on which you're growing your crops, there's nothing you can do about it. Nothing at all. So, how can we apply that across to solar panels? Well, the general view is that a solar panel, not being an aperture in a building through which light passes, cannot benefit from a right of light. And indeed, if you look at the report which the Law Commission gave on rights of light back in something like 2012, something like that, it's a long time ago now, they were absolutely clear that for that reason, because a solar panel is not an aperture in a building through which light passes, therefore it is simply not capable of benefiting from a right to light. And that's even if a right to light was expressly granted in favour of solar panels. It simply would not work. So if you do not want next door interfering with the access of sunlight to your solar panels, what can you do? Well, obviously, you may well have a remedy in terms of objecting to them getting planning permission. And there was a case not long ago where planning permission had been granted and it was actually quashed by the court because the planning committee had not taken account of the damage to the access of sunlight to the nearby buildings' solar panels. So that's the starting point to actually object to the planning application for the development. The other thing you could do is actually impose a restrictive covenant on the land that might build and conflict with your access of sunlight to your solar panels. I appreciate, by the way, that solar panels do not need sunlight in order to operate. They just need light. But obviously with sunlight, they work rather better and you get rather more solar power than if you just get ordinary light and not sunlight. So as I say, that's the other alternative. You simply burden the land that might be built on by a restrictive covenant, preventing any building that would interfere with the access of sunlight to the solar panels, or indeed giving the owner of your land the right to approve the drawings of any proposed development. And then obviously you can look at the drawings, you can see whether it will interfere with the access of sunlight, and you can refuse consent accordingly.
That's great, thank you. So another one for David here. So should I be refusing to accept undertakings from firms trading as an LLP or limited company?
I think the short answer is not if you want to get any work done, no. But I mean, obviously this is the Harkus case. I mean, the Supreme Court did say that there are limitations on their ability to enforce undertakings given by LLPs or limited companies. But as I think I said in the presentation, that doesn't mean that there aren't remedies available. And yeah, we've all been accepting undertakings from licensed conveyancers for a number of years, and they're not subject to the court's jurisdiction either, and never have been. So to that extent, I think whilst the case is important, and I thought it was important enough to include in the presentation, it was mainly to make people aware that this issue might crop up. You might be asked to provide an undertaking by an individual to back up an undertaking given by an LLP or a limited company. But I know the short answer is no. I don't think you should be refusing. It's certainly worth having a look at the judgment and making a decision as to whether you should be, as one of the insurers is suggesting, whether you should be trying to explain to your client the limitations on an undertaking you've received from an LLP. Frankly, the client's not going to be in the slightest bit interested and wants to know why on earth you're just holding up the exchange to talk about this legal nicety. But essentially, the short answer is no. The Law Society are, in inverted commas, working on it. But as I know from working with the Law Society, that is a very, very slow process. There is going to be some sort of guidance from them. At the moment, I get visions of people sitting around in the reading room, scratching their heads, thinking, "Well, we've got to do something. What should we do?" I'm slightly afraid that it might turn out to be, "We need to do something. There's something. We'll do that then," which is a bit like they've done before. But we'll have to wait and see. But no, the short answer is no. I don't think you should be refusing to accept undertakings. You might want to think about possibly asking that the undertaking be backed up by a personal undertaking. But frankly, I think, as I said in the presentation, I was in practice since 1977. I don't think I ever in that time had to take any proceedings to enforce an undertaking. The odd snotty letter or the odd sort of phone call to the senior partner maybe, but that's about it. And so I think the case, whilst it raised an important law point, I think is probably going to turn out to be a storm in a teacup. So carry on undertaking, I suppose. There's a film in there somewhere.
We've had a question. Could you repeat the case name that you were referring to there?
Yeah, it's hang on a second, let me just look at my notes. It is Harcus, Harcus Sinclair versus Your Lawyers, 2 words, and the citation is 2021 UK SC 32. So 2021 Supreme Court decision 32. So just search for Harcus Sinclair Supreme Court or something. You'll find it. And always, of course, the full transcript will be on Bailey or Bailey-O, however you pronounce it. I'm never too sure how you pronounce that, but the full transcript is available online.
Great, thank you. So moving over to Peter now. So how long can an obligation to pay overage last for? Is there a time limit?
Well, the answer to that is no. There is no time limit. Good on you if you can get an obligation to pay overage that has no time limit. Brilliant. Not so good if you're the unfortunate person who's actually agreed to pay overage with no time limit. Obviously, normally it's a matter for negotiation how long the overage will be payable for, or during how long a period overage will be payable if the relevant event occurs, normally grant of planning permission or something like that. There was an argument before the new Perpetuities and Accumulations Act 2009. There was an argument that overage was subject to the rule against perpetuities. Personally, that's a really technical legal point. Personally, I never thought that was right. There was a footnote, I think, in McGarry and Wade that implied perhaps there was some kind of limitation. And indeed, I think, to be fair, some people did think there was a limitation. I'm told that when the National Trust sold land, they used in the old days to impose an obligation to pay overage which would last for 80 years. And of course, the whole point about the rule against perpetuities before April 2010 was that it was limited normally to 80 years. So that looks a bit suspicious. That always makes me think perhaps some barrister advised the National Trust at some point that it was dangerous for them to go for a period that was not limited to a maximum of 80 years, and that was what they went for. But as I say, nowadays, since April 2010, there has been absolutely no time limit, and it's up to you how long you can get overage to be paid for.
That's great. So moving back to David. So what should I be telling clients about in respect of the EWS1?
Oh, that's the $1 million question, isn't it? The bottom line is, I think the Law Society have stepped in here with their guidance aimed at consumers rather than you and I. and making it very clear that we should be making great strides to make sure we're not taking responsibility for the EWS1. And we need to make it very clear to our clients that we are not going to be responsible for advising them on whether the building meets fire safety criteria and whether it needs an EWS1 or not. So I think the short answer to that is have a look at the Law Society guidance note, which I say is aimed at consumers, and that makes it quite clear that effectively the solicitor will be able to tell you, i.e. the client, whether there is an EWS1 or not, and we'll be able to basically do little more than that. Essentially, just let you know whether it's there, and if it isn't there, who's responsible for finding out and whether any money might be available. Yeah, good luck with that. But essentially, the answer is, I think, only say to the client, you should only be asking the question on the other side, is there an EWS1? And yeah, is it needed? I mean, the government have come up with two, as I said, two contradictory guidance notes, one saying that it's needed for buildings of any height, and one saying that it's not needed for buildings below 18 metres. And the brainstorming session, which came up with them saying you don't need an EWS1 if a building doesn't have cladding. Well, shit, Sherlock, that must have taken them a long time to come up with that one. But essentially, the answer is, I think what we should be telling clients is, as it says in the Law Society guidance, that we can find out whether an EWS1 exists. And that's about it. We can't take any responsibility for finding out whether an EWS1 should be in place. That's a matter for a surveyor and for surveyors and other professionals, fire industry professionals, not you or I as solicitors. So just have a quick look at the Law Society guidance note, and I think that's the line we should all be trying to tread.
Okay, that's great. Thank you. One for Peter now. So they write, surely if planning permission is not required for a development due to a change in the law since the overage provisions were drafted, the seller would still be entitled to receive overage as though planning permission had been granted.
Well, that's a really interesting suggestion, and yes, from a moral point of view, you might well argue that even if planning permission wasn't required, if that's something new, if that's a change in the law, and it is the way the government seems to be going, they seem to allow more and more things to be done without needing planning permission nowadays due to their desperation to get as many houses built as quickly as possible. Yes, as I say, you would hope that the answer is, well, if the overage provision says overage is payable if planning permission is granted, and planning permission turns out not to be needed, then overage will still be payable. The problem is the courts have tended to take quite a narrow view when it comes to the drafting of overage provisions. And if an overage provision says overage is only payable if planning permission is granted, and planning permission isn't granted, then why would the court uphold overage still being payable? And I fear that that is going to be the case. So you may want to think first about how you define planning permission. Do you want to define planning permission to include deemed planning permission, for example, where a statute or a statutory instrument says that planning permission is deemed to be granted? And another possibility, you might want to say that overage is payable on the grant of planning permission, or if planning permission is not required, then overage is payable on the commencement of building work, for example, or something or along those lines, because you do need to be warned, the government more and more allowing, well, first of all, allowing conversions, allowing offices to be turned into flats and this kind of thing. That was temporary, then it was made permanent. Now we've got the ability to build 2 stories of flat sites on top of lots and lots of buildings where it's appropriate to do so. And I think, I think that this is only going to happen more and more, because it's a jolly good way of allowing residential development without it taking too long to get planning permission, basically.
That's great, thank you. So on for David now. So how do I know if a software provider meets the Land Registry's digital identity standard requirements?
Okay, well, having been rude about the drafters of the law of the lease, the Law Society, and now I can upset the Land Registry as well. So, yeah, it's a perfect hat trick, this, isn't it? But the answer is you don't very easily. The practice guide and the practice guide 81 makes it clear that in order to meet the Land Registry's digital requirement, the provider's liveness test, which is the taking a video of yourself and blinking and looking left and looking right or whatever, their software has to have a failure rate of less than 0.001%. Now that's fine. I mean, I think lots of companies will say that they probably got that software that's that reliable. And you'd have thought that one of the things the Land Registry would have done in launching this digital standard would be to have a list of people that met that criteria. I did pose that question, and the answer was basically, no, we haven't done that. So I think they're working on it, I was told. Last time I spoke, I was in touch with them about it or heard about it, they were working on it. So I think at the moment, the answer, I suppose, is going to be ask the provider. I know there are some providers that claim that they do meet the criteria. Well, fine. Put them to the test and ask them, do you have software that meets this criteria? But as I understand it, and as I haven't checked for a little while, but last time I checked, there wasn't an actual list of approved software providers provided by the Land Registry. I suspect that will come, but last time I checked, there wasn't an actual list. So the answer is simply ask the provider and hope that they don't lie to you.
Oh, let's hope. Thank you for that. So back to Peter now. Does the burden of a restrictive covenant always run with the burdened land? If so, isn't it possible to word any covenant restrictively?
Well, the first question, the answer to that is not necessarily. Basically, the burden of a restrictive covenant will only run with the burdened land if it satisfies the 4 requirements that were laid down by the court in a case called Tulken Moxhay, right back in the 1840s. I think it was 1846. When they were actually dealing with Leicester Square. And those of you who know Leicester Square in London will know that it is still not built on. So that restrictive covenant obviously stood up very well indeed. So Tulken Moxhay laid down 4 requirements. And in particular, one of the requirements was that the covenant needs to actually benefit the benefited land as land, not the owner of the benefited land. And that is the reason why a restrictive covenant that secures overage, the burden does not run with the land, because the obligation to pay money, clearly it can benefit the owner of land, but it doesn't benefit the land itself. That's the whole point. So first of all, if your restrictive covenant, the burden is to run with the burdened land, you're going to need to satisfy the 4 requirements in Tulken Moxhay. Secondly, though, the second part of the question, can you not always word your covenant in a restrictive way? Well, yes, you can, obviously, but it's only a restrictive covenant if what it is saying is truly restrictive. So, for example, a covenant not to allow a building to fall into disrepair is basically a covenant to repair, and that is a positive covenant. a restrictive covenant, a true restrictive covenant, is actually restrictive in some way. And just by sort of cunningly wording it so that it sounds restrictive is not going to turn it into a restrictive covenant.
Great, thank you. So one for David now. So, am I responsible for finding out if my buyer client has lived in the UK for enough time to not be required to pay the overseas buyer surcharge?
Okay, that's an interesting point. It goes to the root, I suppose, of what exactly is your responsibility as a solicitor in completing the SDLT return. And the answer is that essentially is to remember the binding point is it's not your tax return. It is the client's tax return. And so it is the client's responsibility to provide you with the information that you need to complete the return accurately on their behalf. So I suppose the answer is I would think it's worth including it in, if you do a stamp duty questionnaire. I know a number of firms that I consult with do have various forms where asking people, you know, have you ever lived outside the UK? Have you ever bought a property anywhere else? Have you, et cetera, et cetera? Are there any other buildings other than the one you're buying? Just generally drawing out information about SDLT. It's probably worth including on that, if you do use that form, that a question along those lines. You know, have you been living in the UK for however long it is? It's 183 days, I think, in the last consecutive in the last 2 years or so. But essentially, it's probably worth asking the question. But if the client says, "Yeah, I'm fine, I haven't," and they aren't, that's not true, then it's their responsibility to make the tax return. So the liability, if any, would lie on them. I suppose the other option, the other point is if you've got somebody who you're dealing with and they're clearly living in, I don't know, in Hong Kong or somewhere, and they're buying properties in the UK and their permanent address is in Hong Kong, and then the question may perhaps arise: should you be taking it at face value? Well, ultimately, we're creatures of instructions. If a client says to me, yes, I'm in Hong Kong, but I've been living in the UK for X number of months, days, years over the past couple of years, and I'm now in Hong Kong temporarily, and I'm coming back, well, I have to take them at their word, because it's their tax return, not your tax return. So I think what I always, my watchword when people ask me this sort of question was, if you're a little bit concerned about anything in a tax return you're doing for the SDLT return you're doing for a client, then one option would be there's a box in the return which says, is the agent authorized to deal with correspondence? Tick no. And then all the correspondence and all the inquiries that the revenue want to raise won't come to you. They'll go to your client, and it's their responsibility to deal with it. So if you've got doubts, just tick the no box is the answer. It takes all the burden away from you and passes it over to the client, which is where it always was anyway.
That's great, thank you. So next we come to Peter. Why was the outcome in the U-Design case different from that in Sparks versus Biden?
Well, that's a really interesting case. Sparks v. Biden was an overage case where basically the buyer, Mr. Biden, having built the houses, lived in one and granted short leases of the others. And when the seller, Mr. Sparks, who was relying on the overage payment to live on in his retirement, when he came looking for his overage, which was payable on the sale of each of the houses, Mr. Biden quite correctly said, well, I haven't sold any of them, so I don't have to pay you any overage. And the court didn't like that. The court felt sorry for Mr. Sparks, and the court implied an obligation on Mr. Biden to sell all of the houses as soon as reasonably practicable. Now, the U-Design case, which I suppose strictly isn't really an overage case at all, it's a contract whereby a firm of interior designers were basically fitting out some luxury flats in Singapore. and they got their payment based on when the flats were sold. But because there was a really serious recession in Singapore, after about 8 years, none of the flats had been sold, and the interior designers, not unreasonably, wanted their money. Well, the interior designers did not get their money, and in particular in the Court of Appeal, they argued that they should get their money on the basis of Sparks v Biden. They argued that there should be an implied obligation to sell the flats as soon as reasonably practicable. And the Court of Appeal, interestingly, went back to Sparks v Biden, and they explained Sparks v Biden in a way that certainly I hadn't understood the case when I'd first read it. The Court of Appeal in New Design said that Sparks v Biden was basically a case of a joint venture between Mr. Sparks and Mr. Biden. And because of that, they felt it was appropriate to imply the obligation to sell, because that was basically the last stage of the joint venture. Mr. Biden had to get planning permission, he had to build the houses, and then the last stage was actually selling them. And that, said the Court of Appeal in New Design, was the reason for the decision in Sparks v Biden. Whereas in the U Design case, it obviously wasn't a joint venture, it was simply a contract. The parties had agreed that payment would be made at a certain point. The Court of Appeal also made the point that, okay, if they were going to imply something into the contract, what would they imply? In Sparks v Biden, it was pretty straightforward. Imply an obligation to sell, then the overage would be payable. But in U Design, there were all sorts of alternatives, and it wasn't at all clear what it would have been appropriate to imply. So that's basically the reason why you get a completely different outcome in those two cases. And I have to say, I was very grateful to the Court of Appeal for explaining that in U Design, because I'd spent a lot of time thinking that perhaps Sparks v Biden was wrongly decided. But now I'm absolutely happy with Sparks v Biden. I know why it was decided as it was.
That's great, thank you. So heading back to David now. So if a covenant requiring consent is expressed to be for the benefit of retained land, will that covenant lapse when the original owner of that retained land dies?
Okay, I suppose this is picking up on the point I made about the case of, what was it, Savage against 60 Kent Road. Which was the Lands Tribunal saying that a covenant saying that the consent of the vendor or his surveyor was required, that covenant lapsed on the death of the original vendor. That, I think, was an outcome of the drafting of that particular provision. I mean, if you look at the case itself, you'll see that the clause in the 1961 conveyance in that case just simply said it was the vendor and the surveyor. There was no reference to it being to successors in title. There was no reference to it attaching to any land. It was deemed by the court, therefore, to be a personal commitment which bound only while the original vendor was alive. And the court made the point that to rule otherwise in that case would mean that the covenant would remain effectively there for infinity, with nobody capable of being able to give the consent. The difference, I suppose, is if that covenant had been expressed to be was imposed for the benefit of the vendor's retained land, then the argument, of course, would be that covenant would attach to that retained land and would therefore pass with the retained land when it was subsequently sold on to other people. So, yeah, if the original vendor had died, that probably wouldn't matter, because the covenant wasn't personal to the vendor. The covenant was actually imposed for the benefit of land that the vendor owned, and somebody else presumably now owns that land in place of the vendor, so they would have the benefit of that covenant, assuming it was annexed properly and fallen down. So I think the point is I was making in the case is that the drafting was very much the classic drafting that you see perhaps a lot in conveyances in the 1920s and 1930s, when land was being sold off as plots with the intention that the buyer would build a house on it, and the owner of the land wanted to make sure that the houses were built to a certain uniform standard. So they imposed the obligation that they could only build in accordance with whatever plans the then vendor or had approved, to make sure that there was some continuity in the development. But I think in that sort of case, if the vendor has died, if it's not annexed to land, the vendor has died, or if it's a company, John Smith's Builders Limited, who no longer exist, I think by extension you could probably argue that covenant dies with that company as well. So I think the answer is no. If the covenant's expressed to bind or be for the benefit of the retained land or for the benefit of a particular piece of land, then it will usually survive the death of whoever imposed that covenant. But if it's worded in such a way that it is clearly personal to the person who imposed that covenant, then according to the Savage case, it will die with on the death of the original person who imposed the covenant.
That's great, thank you. And moving over to Peter now. So, does an easement come to an end if it is not used? How long a period of non-use is required?
Well, the short answer is that an easement basically almost never comes to an end unless it is expressly released, no matter how long it is not used for. And there was a case where an easement had not been used for 175 years. And the court said, so what? There are cases where, for example, a right-of-way couldn't be exercised because a wall had been built, actually blocking off the right-of-way. And when the court was asked, well, does that bring the right-of-way to an end? The court said, well, the wall might be knocked down at some point in the future. So, basically the answer is don't try and argue that an easement has come to an end simply because it hasn't been exercised for a long time, because, frankly, if 175 years isn't long enough, then, just don't try it. Just don't go there.
I think adding to that is, I don't know which case you were referring to, Peter, but there was one that I used to deal with in my update courses where the buyer of a piece of land actually agreed to put a fence up to block a right of way.
Yes,
that's
yes,
it. And
that's right.
the court, even in that case, the court said, well, that didn't that wasn't an abandonment of the easement for the very reason that they might take the fence down again. Bottom line, I think the lesson I learned from that,
extraordinary, isn't it? Yeah, exactly.
The lesson I say to people from that case is essentially never assume that an easement has been abandoned or ceased to exist.
Absolutely,
it will outlive us all.
That is so true. Yeah.
I think we've got time for one last question, so we'll come to you, David. How accurate is the estimated date for completion of applications given the Land Registry portal?
Okay. Another chance to be rude to the Land Registry. The answer is it's incredibly not accurate. I wouldn't rely on it in the slightest. It's simply a snapshot of an estimate based on the number of applications of your type that they have completed successfully within the last 30 days. The only purpose I can think that might be used for that date is to basically tell a lender to stop bothering you by if they keep sending you notes saying when are you going to complete our registration, then just send them a snapshot or a screenshot of that and say, look, that's what the Land Registry say. And I've seen one only this week where the time estimate was September 2022. So you can say to the lender, no, I'm not going to be sending you the title deeds in evidence in the next 2 weeks because there are reports of lenders saying, I'm going to put you off the panel because you haven't registered. Well, not my fault. This is what the Land Registry is saying. So bottom line is it's not very accurate. I don't think. I think the only purpose it can really be used for is a weapon to make to help you beat off developers who seem to not realise that the land registry is in some disarray in regard to some of their registrations at the moment. I should probably have my land registry account. Will probably be suspended when I go back in a minute. Yeah. Just so I've only got some searches to do this afternoon. So yeah. I'm sorry, Mr. Land Registry. I didn't mean it.
So unfortunately, that is all we have time for today. Thank you for attending Law 2021 Online Residential Properties Shape the Debate. Don't forget to join the Solicitors Group Law 2021 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning of today's recording, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinars. There is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the Webinar Learning Catalogue worth £35 plus VAT. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. So again, thank you again for joining us. Thank you again to both of our speakers, and we hope you have a great day.